Hey everyone, it's Rob Ryder on Friday, January 8th, 2021. And before we get started, I want to say her name, Ashley Babbitt, the 14-year Air Force veteran who was executed at the Capitol a couple of days ago. For what reason, I don't know exactly. There's lots going on there that, someday we'll get to know the whole story. But the idea of the deep state, right, it isn't just at the Capitol. It goes all the way down to your local government, which in Michigan is either a city or a township. And, that's what this video is about, right? Is there's many ways that we could be fighting the deep state, and we need to understand a few things better and, and stop being so passive on all the errors and omissions that are in paperwork that these people give to us. And at most any video I ever do, I'm showing all sorts of errors and records, and this will be no different, right? But in this case, as it turns out, a friend of mine, Dana Reed Smith, is going to have a court case on January 20th, order to show cause hearing, on why they shouldn't take his property for not paying taxes. So, they want Trump to move and they want Dana to move. Forever taking your property. There you are. Different situation, but, personally it's about the same. So anyways, this is what they're doing. And, I knew that Dana had this coming up. And I had done some videos recently on a few other subjects. And all this stuff is tying together at this particular moment. And I'm going to try to sit here today and weave a little web of facts and details and hypotheses. And I have people go out and get some information to actually go out in the field, do a little work, do a little checking it out, go ask some questions, come back. What'd you find out? Right? What'd they say? And see if we can move it a little bit further. But in this case, it's classification assessment tax used as deep state tricks of the trade. This is why you need to know your PID, which is your parcel identification number. That's what they call it in Michigan. I can't say it's the same everywhere. But, it's not a parcel number and it's not a property identification number. No, it's a parcel identification number, right? That's the thing you need to know, because these other ones are numbers that they make up so that you don't look for the parcel identification number. And they'll act like they don't know what you're talking about, probably, because all they know is parcel number and or maybe property identification number, right? So it'll make more sense in a second. But because of these errors and omissions in local government land records, it disenfranchises electors in the United States, turning the nation's creditors into homeless debtors. Because there's errors in the records, you don't own your property. It's really that simple. There isn't anything in your real estate transaction that has your full legal name on it as you as a living person. Person is the proper term, right? Legal person, natural person, artificial person, those aren't. Those are all modified versions of person. But a person is a human being, right? Spirit-filled being. Go look at Webster's 1828. Whatever he said, that's what a person is, right? In this particular discussion. You want to use something else? Well, then don't use person. I don't know what to tell you. But I'm using it because it's okay with Webster. It's okay with me. But this is what they're going to do. They're going to put errors in records intentionally. And then by doing that, they're going to keep your name off the records, and you really don't own anything. You just pay all the time, right? You're paying taxes. So it gets even worse than that the fictitious piece of paper they put into your record to say, well, this is your deed, and that document doesn't have your full legal name on it, doesn't have a proper legal description, and none of this stuff is correct. It's just shit that a lawyer puts on paper and says, here, use this. They're full of Scrivener errors. That's the proper term, right? It's Scrivener errors. Well, if you don't change those, then whatever the record says is what the record says. And so if you don't change it, it's your fault. You didn't defend your rights. Now, you may not have known this yesterday, but after today you will. And if you don't do it, well, then you're not defending your rights. And they're not responsible for it because they don't know it necessarily either. They're just doing whatever they've done since whenever they got there. But once you tell it to them, well, now, they would have to do the right thing, or they cannot claim that they didn't know anymore. Right? You take away their ability to have deniability. So, Rob Ryder, email, quarterrecord@AOL.com. My phone number is 616-712-6179. And if you can, please help to keep the lights on by sending a donation to PayPal to my account, Rob Ryder, ROBBRYDER, @AOL.com. Or you could send me a request for an invoice, right? And say, Rob, send me an invoice for X number of dollars, which would come to you through PayPal, and then you could use a credit card in case you don't have a PayPal account. And see how handy they make that stuff? Or you could just stick it in the mail. Robert Allen Retluski, 10955 14 Mile Road Northeast, Rockford, Michigan, 49341. Because for all you people who own land and property, I don't. And yet I'm going to do this video just on land and property and show you the path to own your freaking property and get off the tax rolls. But you got to go do it. Right? This isn't something I can do. I'm not an owner. I'm a renter. So let's talk about this for a minute. Just give me just a second to load up a few things. Okay, now you're going to have to bear with me for the next 5-10 minutes as I weave a bunch of things I've had going on in different areas together so that I have caught things up. But because this video is going to be about this idea of something to do with your residential property, right? So this is for people who believe they own a house. And specifically for people in Michigan, right? If you live in Michigan, you can go do everything I'm going to show you today by yourself. You wouldn't need my help at all. You just need to get off your ass and go ask some questions. Now, if you don't live in Michigan, well, I can't say all this stuff matches exactly, and you're going to have to go do a little investigation on your own. But when you figure it out, tell me what you did, and then I'll tell other people in your state, and they can do it. Right? But I'm not here to save people, right? Because I can't do these things myself. So I'm just here to share some information, and you go save yourself and then tell us how you did it. But in the State Tax Commission recommended classification codes adopted by the STC, well, that'd be the State Tax Commission, on April 9th, 2018, they have all these different codes for property, right, in Michigan. Now, it's either categorized as real or personal. Right? Special, real, special, personal, whatever they want. They got something for everybody, right? But the point is, if it's classified as real property, then you pay real property taxes. But if it's classified as personal property, well, then you don't pay real property taxes. Now, you got all these different kinds going down here. Here's commercial, industrial. We get to residential, right? You got 401, 402, 403, and you'll see there's a few more here. But see, all of these are real. Now, 401 residential improved is no more than like a vacant lot with a freaking utility pole on it. That's how it was improved. I think 402 vacant is just vacant land. 401 improved is vacant land that has at least some kind of improvement done on it, like, bring in a power pole. Really that simple, right? That's all it takes. Well, that's how they have most people's property in Michigan. Right now, it's being classified as, not zoned, classified, right? Different thing. And it's zoned as 401, so you pay real property tax, even though you have much more than a power pole there now, right? So if we continue going down, you would see that eventually you get to residential personal, right? That's personal property. They got residential leasehold improvement. Well, that's personal property. Well, they got residential conservation reservation, reserve, whatever. I don't know what the rest of it is. I have to look that one up again. But it's like, if you own less than 160 acres and you got trees on your property, you can classify your property as a fucking reserve. Now, that's more difficult than I want to do. Personally, I think that this 451 residential personal is the one that anybody who owns their house could have. Right? It's just a matter of getting the classification changed, because right now it's classified as 401 or 402 or one of these other ones where you pay real property tax. So that's what the video is mainly about, right? But because I got lots of things going on, I wanted to point out, obviously we all know that on the 3rd of January, Congress got together, right? So January 3rd, 2021, this is the Congressional record of the day's events, and they're going to swear in the dean, and then we're going to swear in the speaker. Mr. Administer the oath of office to Ms. Pelosi. Okay, so this is where Pelosi's taking it as the speaker, right? And here's the oath she's taking. Do you solemnly swear? If you've watched my videos in the past, you know what this one is. This is the oath out of the United States Code, Title 5, United States Code, USC, Section 3331. This is an oath for employees. This isn't an oath of an officer under the 6th article of the Constitution, which says in the 6th article, right, that the senators and representatives and executive and judicial officers of the United States and of the several states, all have to take an oath to support the Constitution, and no religious test shall ever be required. And yet here we have an oath that says, so help me God. Well, as I've said many times, this isn't the oath that satisfies the 6th article of the Constitution. What they did, right, from the beginning, the very first law passed after the ratification of the Constitution is this an act to regulate the time and manner of administering certain oaths, 1 Stat 23. You can go find this on the government website or all these other sites. I mean, I've shown it many times. It's not hard to find. I'm just showing it here because it's the first one that came up. But what I want to show you is it says right in the act, right, that this is the being enacted by the Senate and House of Representatives of the United States of America, Congress assembled, that the oath or affirmation required for the 6th article of the Constitution of the United States shall be administered in the following form, to wit, I, A, B, do solemnly swear or affirm that I will support the Constitution of the United States. Period. That's the oath that satisfies the 6th article of the Constitution. It's never changed. That is the oath that satisfies the 6th article of the Constitution. And Congress didn't take it. And they're supposed to. So, Army, I really want to know, well, how come you're allowing these people to pretend to be the Congress? Right? Because if we're not going to enforce the first law passed in the United States after the ratification of the Constitution, then why would I expect them to follow any other law? We need to go all the way back to the beginning, to the very first law, which is this one, and follow it. And if we would make these people take the proper oath of office, well then, it would be a different world. Now, the people that are in these offices, they can't take it because they've already committed treason. My point is, I'm not asking them to take it. I'm telling you, get them out of the fucking office. Right? They're a traitor. They didn't take this oath. What they did is they submitted a counterfeit. Right? What's the proper thing to call when this is the oath you're supposed to put in, but you instead insert this oath? Now, they're supposed to take this oath and then subscribe it, and get 2 copies from the clerk, subscribe it, and go file it with the clerk's office, and that's supposed to be the evidence, and it's all in there. This has all been laid out in Title II, United States Code, Section 21 and 25, I think it is, where one is when the senators take the oath, the other one's when the members take the oath. It says what they're supposed to do. And it's not happening. Right? So I had to say it again, just because it's the stuff that's going on. Hang on just a second. Okay, and one other thing before we get on to property taxes is, since I was talking about taxes anyways, and I had wanted to talk about this particular subject, right, that because IRS is coming up again for people. If you Google IRS 6209, right, just IRS 6209 or 2020 document 6209, whatever you want to do, you can find this without any problem. Right? In fact, let me just go back a couple pages here, because I like people to go find this stuff themselves. IRS 6209, right? Document 6209. Hey, let's go look at that. Then you have all these different editions, and it doesn't really matter which one you pick for our purpose today. We're going to pick one. And if you go to, well, let's start at 4 first, right? So go to section 4. Oh, okay. And on section 4, it will say on the first page here, we're just going to talk about making up this DLN, which I don't remember exactly what DLN stands for at this moment, but what I wanted to point out was that the third digit is the tax class. The third digit is the tax class. The third digit is the tax class. This identifies the type of tax each transaction involves. And as you see, there's 8 of them, right? Well, 2 is the one that says individual income tax, where 5 says information return processing, estate, and gift tax. What it doesn't say is it doesn't say individual income tax, right? Which is what people are supposed to be paying for taxes for, because 3 is corporate tax, right? Corporate income tax and individual income tax. So if it has to do with a tax, it's code 2. As long as we can all agree on that, then hey, we're still on the same page. Now let's go to section 2. Because in section 2, it lists all the different forms used by the IRS. Right? And all these forms in section 2 have a tax class tied to them. Right? Hey, there's 2. Well, that would mean that goes with individual income tax. Well, there's a 5. Well, that means that's gift, estate, or information. And so each of these means something, da-da-da-da. So I guess what I would do is go back the other one and print that first page out so that you can remember what all these are. But let's go look at what some of them are, right? What's W-2? Well, that's a 5, right? It's not a 2. It has nothing to do with income tax. Well, then why are you using the numbers on it on your income tax, right? It's a 5. It's not a 2. This is like Geronimo's putting your freaking clothes together. The 2s go with the 2s. 5s go with 5s, right? All these things are 5s. 5, 5, 5, 5, 5. W7s are 2s, right? Did you fill out a W7 or did you fill out a W4? Now, I know that when people fill out a W4, right, that if you look at the form, in fact, I should go get one since I'm going to go to that depth. Let me go. Anyways, I plan on doing much more thorough video on this here soon, but I wanted to show these few things, right? That here's a W4, and it says name, first name and middle initial. So you do it to yourself by putting in a middle initial in that box. Now, your first name is, in my case, it's Robert Allen. It's my given name. I don't have a middle name. And if I don't have a middle name, then I don't have a middle initial. But we've been trained to think we have a middle name and to put in a middle initial. Well, as soon as you put a middle initial in here, instead of your name, you're hiding your identity. Right? So Robert Allen Retluski should be in here, not Robert A. Retluski on a W4. Right? So I'm just showing you that, they lead you into self witnessing, your own status. You did it to yourself as far as they're concerned. Okay, then we got, so the next thing is, well then, what's a 1040 for? Or why do we fill out 1040s? That's what I want to know. Why do people fill out 1040 for? A 1040 is for a 2 and a 6. It's not for a 5. Right? 5s go with 5s. 2s go with 2s. 6s go with 6s. So, and then some of these, they don't have any tax class with them. So what does that mean? So anyways, this is why I have to hold another video on this. I'm just showing you that all of these things, let's look at the 1099s real quick, right? They're all 5s. 5, 5, 5, 5, 5, 5, 5, 5, 5, 5. Not a one of them has a damn thing to do with individual income tax. So quit treating them as individual income tax. Now, that's when people say, oh my God, now the IRS is going to come. Well, that's probably true, right? Well, if you do this, the IRS will probably come. And that's when you need to go open the $60 court case with the commissioner as the defendant and tell him what's going on and see what he has to say. Right? Either you're going to have to pay the tax or you're not. But the way not to pay the tax is to go argue it with the tax commissioner, because in the tax court, you don't have to have paid the tax first. But if you go to the district court or any other court, you have to pay the tax before you can argue it. Right? But in the tax court, you don't have to do that. And for $60, 60, you can open up a court case. So that'll be something for the future, right? Okay, well, I wanted to pull that up too and talk about it for a second, just to say that there's lots of things to do with taxes that if we were to do it differently, would bleed the frickin' deep state because that's their lifeblood. Right, so let's get back to the closer version of what they're doing. So give me just a second here. Okay. A few videos ago, I did this video called Requests for Admission Equals Evidence. You should probably watch that. Right? Because there's this idea that requests for admission is a form of discovery used in a court case. And as a defendant, you don't have to ask leave, you don't have to file for a motion or anything else to ask for requests for admission, which is you forming statements to send to the other party, the plaintiff in this case, we'll say, right, that they have to answer. Yes, no, or they have to object. But whatever they do, they have to do it under oath. And if you've paid any attention to my videos over time, I'm telling you, the plaintiff doesn't exist. They're not using the full legal name of any plaintiff ever in any court case. That's why, in this one, this was back when SCOTUS, the Supreme Court, told Texas they didn't have any standing. It's because state of Texas isn't the proper name of Texas. State of Texas is the name that was used by Texas when it was part of the Confederacy back during the Civil War. Right? So now it doesn't have any freaking standing in the Supreme Court. So, well, there you are. So the idea then for us is because the plaintiff doesn't exist, if you ask the plaintiff questions that they have to answer under oath and they can't answer, well, they're not questions. They're not really questions. They're statements. Right? Then if they can't answer, then they agree. So in other words, silence equals acquiescence. And I hear people say that stuff all the time. Well, they didn't answer me, so they agreed. Well, this is how you get that to be proved by a court as evidence, because it's part of discovery, which is evidence. Right? So you need to, so that was my thought process at the time. And so in this video, I helped a gal out in California put some things together to put into a court case, which are in there now, and now we'll see if they're going to answer. Right? And I'll be doing another video on that in more detail here yet also. But because I was doing that, I was looking for other evidence of requests for admission. And that's when I found this. If I can ever get it up here. Okay, I'm kind of reverse engineering the last couple of weeks, right? So because I had been looking for things to do with requests for admission, I had put in Michigan request for admission into Google, and hey, I found this piece of paper here, which was from the Department of Labor and Economic Michigan Tax Tribunal. Between a hotel and the city of Lansing. And, well, let's just read it real quick, right? Corrected order granting petitioner's motion for summary disposition. Well, who's the petitioner? You mean the hotel won over the city? Yeah, that's what this is saying, right? The hotel won this round, corrected order granting petitioner's motion for summary disposition. And what you said, the December 2006 order granting petitioner's motion for summary disposition applies to the tax years 2003 to 2006. The order is to be interpreted as an exemption of the personal property in question identified as parcel number, right? And then they're given this parcel number. Respondent has admitted that during tax years 2003, 4, 5, and 6, there was no transfer of ownership. The tax classification of each parcel did not change. No additions or losses were attributed to the parcels for those years. In other words, they agreed with them, right? Because so that was the amended. This is the original order, right? The petitioner served respondent with petitioner's first request for admissions and production of documents on June 20, 2006. Respondent failed to answer or object to any therein within 28 days of service of petitioner's first request for admissions and production of documents. Thus, in accordance with MCR section 2.312B1, each matter contained within the request for admission is deemed admitted by respondent. Well, that's huge, man. I mean, this court just agreed with the plaintiff that because the respondent didn't answer, they agreed. Now, that's huge, right? Because it's hard to find any time that a petitioner wins against the government, but that's what this is, right? This is a tax case where the city of Lansing is, the taxing authority, and Candlewood Hotel Company Incorporated is a petitioner, but that could just as easily be Robert Allen Retluski, right? It's just who's the petitioner. The point is that when they got to this Michigan Tax Tribunal, they were able to, this is administrative court basically, and through discovery, even the plaintiff can file requests for admission, but the plaintiff didn't answer. I mean, the respondent didn't answer, so they agreed. So that's what this was about, right? So that's huge. So anyways, that's why I had gone to find, after I'd found this, I said, we could use this Dana's case. And so I started to look closer, again, at things to do with residential property, and that's when this whole thing kind of mushroomed. And so while this is still good to know, I don't know that we need to use this. My point in just in showing this is the fact that a tribunal in Michigan agreed with the plaintiff, right, that each matter contained within the request for admission is deemed admitted. Petitioner Candlewood Hotel has filed a motion for summary disposition based on respondent's untimely response. So this is what you do with it after you get it, right? Now you got to file a motion for summary disposition to petitioner's request for admission pursuant to some other rule. Due to respondent's untimely response, there is no genuine issue of material fact, right? Because the respondent didn't answer, there is no genuine issue of material fact. That's the part to remember why you're asking for a summary disposition. Because due to the respondent's untimely response, there is no genuine issue of material fact. This is a court telling you what to write in your paperwork. Right? So, I bet you if you were to Google MTT docket number 302362, you could find this document if you want to look at it. I don't know that we need to use it, and I'm going to show it more in another video. I'm just showing you that there's more than one way to skin a cat. And this is why in the case out in California that I showed you, well, there's one of these already in, right? Now, it has nothing to do with taxes. In Christina's case, it's a debt collector. So I want to show you this list I'm making up for people for other cases like traffic cases or criminal cases or tax cases or anything where people are acting as the government. Let me put it that way, right? So I think it's worth showing you right now. Let me go get that thing. Hang on. Yeah, this won't take a minute. I know I'm mixing a whole bunch of different things together, but eventually we'll get to the property taxes, right? Just bear with me. Just watch the video. Go back, watch it again, right? Because all these things are important to different people that I've talked to here recently, and I want to make sure that I've covered them so that they know what's going on. So in Christina's case, right, this is in California. Well, they actually have a form for this, right? This is a request for admission form, a discovery 020 form. And I had found on some other form where they had, when they did it, they put the person's name and put in pro per behind it. So I said, well, that's what we're going to do. Right, and there was something. See, this is covering up what was there, but Christina Francis is her name, and then her address is Christina Francis, right? Because she's a business. She's the owner of this business, Christina Francis. Da 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 da. And they're the attorney for Francis, Christina, who's supposed to be the defendant in Superior Court of San Diego, and all this was filled out. This is all filled out. I just want to show this form, right? That was her court case number. All this stuff just came off of things that she already had, but at the time I didn't have the address and stuff. But when we sent it in, all this was filled out. I wanted to show this form because here it shows answer to request for admission, right? This is what they have to get back to you, must be given under oath. The answering party should use the following language at the end of their response. I declare under penalty of perjury, under the laws of the state of California, the foregoing answers are true and correct. Right? So that's what they got to put. If they don't put that, well, then they didn't do it right. They didn't answer your request. So they can't deny it. They can't do anything other than object to it or answer it. Yes or no, but they have to do it under penalty of perjury. So in her case then, it was this debt collection case. So here's an example, right? This was the statement. The entire name of plaintiff is Brixmore Felicita Town Center, LLC, a Delaware limited liability company, which is the name they have it as the plaintiff. Well, there is really no business with this name. That isn't the business name. There could be a name, Brixmore Felicita Town Center, LLC, right? But it doesn't have this addition on there. Somebody did this purposely to make something that does exist, as in this case, an artificial person. They turned it into a thing by adding more words to the name. So it's no longer Brixmore Felicita Town Center, LLC, registered business in some frickin' jurisdiction, but now it's a thing that just looks like it is. Right? Well, this is the kind of shit that they do. This is what lawyers do. This is attorney work. This is the work of esquires. Right? So that's an idea of, well, that's something to ask them. Well, how are they going to answer that? They got to answer it. Right? The following state of facts is true. The entire name of the plaintiff is. Okay, well, that obviously wasn't the only question. Now here's some more. Plaintiff did not sign, seal, and deliver a bilateral business contract with defendant. Right? The plaintiff didn't sign anything and give it to the defendant. They don't have a contract. Christina may have signed something, but the plaintiff didn't sign anything, so they don't have a contract. Right? Plaintiff is not a business entity registered with California Secretary of State. Any properly registered business is supposed to be registered with the Secretary of State, especially if they're coming from out of state. They got to get like a certificate of authority, is what they call it in Michigan, to do business in your state. If they don't have it, well, they don't have any standing in the courts. Plaintiff does not have legal standing to sue or be sued in California, United States. Well, there you are, right? Agree they don't have any authority. Plaintiff is a conspirator in a malicious prosecution of defendant. Well, that would be good. Can't answer. If they can't deny it, then they agree that the plaintiff is a conspirator in a malicious prosecution of the defendant. And 5, the attorney for plaintiff is plaintiff's malicious prosecution conspirator. Basically, I'm trying to get them to, self-confess on themselves that it was a malicious prosecution so that Christina can then go to the judge and say, Judge, they agreed it was a malicious prosecution. And the attorney has what do they call it? Liability insurance for malicious prosecution. And I showed this in a number of videos back around the March time frame. Read the back of the can, right? Start there in about 3 or 4 videos all about insurance and what's in a freaking insurance policy. Well, as it turns out, malicious prosecution is a intentional tort that has been covered by insurance. All we need to get them to do is agree it was a malicious prosecution, and then the judge, who does have jurisdiction over the attorney, right? Now, again, this judge didn't take the oath in 4 U.S.C. 101, so he doesn't have any authority over you anyways. But he has authority over the attorney, because they're both in the bar. So he can tap his insurance policy and get you paid. Right? So that was my thought process on that. Now, that was on that one, so I was thinking, well, that ain't quite enough. What else can I think of? So this is for, one when you're dealing with the government. In that case, it was a business, but this is the government, like tax case or a traffic ticket case or state of Michigan case, criminal case, or whatever it is, right? Just or child support case. Who called me? Somebody called me yesterday whose children have been taken from them, right? So child protective services. Well, whoever it is, they're doing it claiming that they're the government. So I don't really care who the plaintiff is. I don't even need to know their name. Just the plaintiff confesses it is not the government. Plaintiff confesses it has no authority to enforce the laws of the United States. Plaintiff confesses it has no authority to enforce the Michigan compiled laws. Of course, a different state, you got to change it. Plaintiff confesses it has no authority to enforce municipal law. Plaintiff confesses it simulated a legal process under color of law in this proceeding. Plaintiff confesses it does not have legal standing in the United States. Plaintiff confesses it is an enemy of the United States. Plaintiff confesses it is a conspirator in a malicious prosecution of defendant. Plaintiff confesses prosecutor is a plaintiff's conspirator. Plaintiff confesses to witnessing perjury by the prosecutor. Plaintiff confesses to witnessing prosecutor impersonate a public officer. Plaintiff confesses that malicious prosecution is an intentional tort covered by plaintiff's general liability insurance policy. Plaintiff confesses it is to its liability for the occurrence of an intentional tort against whatever your full legal name is and authenticating numbers such as driver's license, state ID. So your full legal name and your driver's license number, social security number, whatever it is. Because your name by yourself, it really isn't your identification, right? Your identification needs to be authenticated by something else, a different document. And that's why they have these numbers, like DOD numbers, EIN numbers, driver's license numbers, so forth and so on. Plaintiff confesses it has bonded these proceedings. So anyways, again, the idea is I don't believe they can answer it. So I'll put the things that I want them to have agreed to, file it into a court case, and see what they have to say. So you don't have to use all these, right? And you don't have to call me to ask me for this list, or you can just stop for a second. Say, yeah, I'm going to use this one here, or I'm going to use them all. Take your time, write them down, whatever you need to do, right? And so this is your list of things that you're using to say the plaintiff confesses to, or make up your own list. But the idea is you can't have compound questions, right? Each statement has to be like an adjudicative fact, right? Checking off, check, 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 check. So this hasn't been used yet, but we'll see what happens, right? I mean, that's the plan. Okay, hey, let's go talk about property taxes now. That's why we're here. Hang on a second. Okay, so let's begin at the beginning, right? This is where the deception starts. So again, all this is pertaining specifically to Michigan. If you're in Michigan, this pertains to you, right? Doesn't matter if you're in foreclosure, late on taxes, doesn't matter. It pertains to you because there's errors in your records. And so they don't like to talk about this parcel ID number, right? Parcel identification number. But if you look at it, it's, the first two digits are the county, the next ones are the township, then you got section, then you got quarter, then you got individual parcel ID. Okay, that sounds simple enough, right? That's for breakdown of platted or unplatted, not subdivided parcel ID. Then you got breakdown of platted. Well, it still starts with the county code. Then you got parcels in the city. Hey, it still starts with the county code. Right? So obviously, it starts with the county code. Well, now let's go look at the problem, right? What's the record say that we're dealing with in the local government? Because this is a tax bill from Blue Lake Township, which the whole thing about this address is funny because Blue Lake Township is in Kalkaska County, yet it has a Mansalona address, which Mansalona is not in Kalkaska County. But as you can see, tax for property, right, 002. It started with the township. It doesn't have the I believe it's 40. Dana's only told me like 100 times, but I think it's 40 for Kalkaska, right? So they want him to pay tax on something he doesn't own. Now, the other thing is they put your name backwards, or they do something to your name, right? So Smith Dana R is not Dana Reed Smith. You don't have to agree to that name, right? That's not your name. It's not your legal name. You only use your legal name in legal matters. You can use any other name you want for any other reason, but when it's legal, you got to use your legal name. You got to use your identification, which is basically the name that's on your driver's license. If you have a real ID compliant driver's license or state ID, then that name is your legal name, and that name is supposed to be used in all legal matters. So if you forget everything else in court, you don't listen to me and you end up in court someday or for whatever reason, ask the judge to tell the prosecutor to pull his driver's license out and read the name into the record. And I'm sure that they'll dismiss the case. Right? Because he's not going to read his full legal name into the record. Okay, so as you can see, right, he's being taxed on something that he doesn't own. Because Smith Dana R is the owner. But on the deed for this property, quitclaim deed, right, I went to Dana R. Smith. Now, there's no commas here, and there was no commas here. You'll see a lot of times they'll put your last name, they'll put, Smith, comma, Dana R, right? But that isn't there. This doesn't even have a comma in it. And all that stuff means something. So anyways, right, they're using a different name. And here's the alleged legal description, right? But what legal description do they use? Right? It's got all this other stuff added to it. So it's a piece of property with a different legal description than what he bought. So he's being taxed for something that he didn't buy. And this whole thing, this whole thing is wrong at the bottom. This has all been, as far as Dana is concerned, this is all forgery. So whether it's a forgery or not, what I know is this thing at the top right here is supposed to be the transfer tax sticker, stamp, and it's supposed to be canceled just like a postage stamp. And this thing has not been canceled. Well, this is actually the ad valorem tax, right? That's what the transfer tax is. It's the ad valorem tax. So while Dana paid for the tax, because here's the stamp, it wasn't canceled. So it's like, they took your money and didn't close the till and hit sale and give you a receipt. There's no receipt for this resale or the real estate transfer tax. This is just part of the scheme. Right? To do that, to use people's middle initial names, because there is no Dana R. Smith. So, actually Dana doesn't even own this as far as that goes. This paper's got all sorts of Scrivener errors in it. But regardless of how bad this is, well, there's the number, right? So that kind of matches this number we saw here, right? But the name is different. And neither of these use the county at the beginning, so it's not the parcel identification number. Well, that's the thing that you own. So that generated a notice, right? And so now we're at this point of, we got delinquent taxes yet. Is this the one? Hang on a second. Get them in order here. Okay, so, eventually he gets a delinquent tax notice from the Kalkaska County Treasurer. Now, that isn't the name of the person that said to pay the tax to. All right, that was Blue Lake Township. Right, so why is he paying tax now to Kalkaska County? Or getting a delinquent tax notice from Kalkaska County? But again, it's got the wrong style property number. It's got the wrong style name. And it says it's for real property tax. Well, there's the problem, right? If you had it for personal property instead of real property, Well, then you wouldn't have to pay this tax because this is all about real property tax, foreclosure. So you need to get the damn thing changed. So what's happening now is here in a couple days, right on the 1/20/2021 at 10 a.m., there's a show cause hearing, right, for this property ID number, right? So this isn't a parcel identification number. It's a property ID number, and Dana doesn't own this property. He owns this property with the county number in the front of it. But what's supposed to happen? Well, when he has this hearing, right, here's the legal description they're using. Again, this isn't the legal description on his deed, right? But this is the legal description that's on the tax, just like this is the property ID. So this property ID and this description go together, but that isn't what Dana owns. Other parties with a record interest in this property may include Smith Dana R. Well, it just said Smith Dana R. So first he's the owner, and now he might also be somebody else with property. I thought you just said he was the owner. How could he be another party and be the owner? The purpose of this hearing is to allow the person with property interest to show cause why absolute title in the property forfeited by the county treasurer, right? This says the county treasurer forfeited the property, should not vest in the foreclosing government unit, which must be the Blue Lake Township. I got to figure out who the FCU is, right? That may come into play, but a person claiming an interest in the parcel of property may contest the validity or correctness of the forfeited unpaid delinquent taxes, interest, penalties, and fees for one or more of the following reasons. No law authorizes the tax. The person appointed to decide whether the tax shall be leveled or levied under law of this state acted without jurisdiction. In other words, they didn't have a proper oath of office under 4 U.S.C. 101, or did not impose a tax in question. Well, I go with jurisdiction. You don't have the oath that's in Title 4, United States Code, Section 101, which is the same oath in 1 Stat 23, which is the only oath that satisfies the 6th Article of the Constitution. Then you don't have any authority in the state. And, Title 4, United States Code, Section 101, is specifically written to state officers that prior to exercising the powers of their office, they had filed this oath of office. I, state your name, do solemnly swear to support the Constitution of the United States. They haven't done it. Right? Well, how do I know they haven't done it? Because they won't give it to you. If they did it, prove it. Right? When you want to know, go find out. And when they give it to you, well, then you can say they have it. Until then, I say they don't, because they've never given me one. I've asked for lots of oaths in the past. I've never gotten an oath that satisfies the 6th Article of the Constitution. And the oaths I do get are counterfeit oaths of the oaths that's required by the state constitution. They're not proper. Right? So they don't have a proper oath, period. The property was exempt from tax in question. Well, that's because, right? Or it was not legally assessed. Okay. This is for personal or for real property tax. I'm going to have it changed so that so everybody agrees it's personal property. Then they wouldn't tax you and you wouldn't have to go through all this. Wouldn't that be a wonderful day? The tax has been paid within a limited or time limited by law. The tax is assessed fraudulently. That could be. The tax, the description of the property used is indefinite and erroneous. Well, yes. This is indefinite and erroneous because it doesn't start with the county. So this is in a show cause hearing, right? So, Dana needs to find out exactly where he needs to be at 10 a.m. on that date with that person and tell them, that this is wrong. It's not the property identification number. I'm going to show you the document to prove it from the treasurer. It's the treasurer that has all this information, by the way. Okay, so anyways, if you didn't do all that, then the next thing is you're going to have a foreclosure hearing on the February 2nd or February 3rd. So 2 weeks later, basically. Right? On this day, we're going to have a show cause. 2 weeks later, we're going to foreclose, take your property. So it's time to shit or get off the pot. But again, they're asking for real property. was forfeited to Kalkaska. Well, it's for non-payment of property taxes, but it's resident or real property taxes that haven't been paid. Well, just again, tell them it's not real property. Get beyond that. Okay, hang on. Okay, so again, this is if you're in Michigan, you're in luck. I've done a lot of the work for you. You can Google this and find it online. It's the Michigan State Tax Commission's property classification, right, which is under MCL 21134C, which is 3 or 4 sentences that they took 24 pages or whatever this thing is, 22 pages to explain. But definitions, right? You got residential real property, agricultural real property, commercial real property. Hey, residential personal property classification. So let's look real quick. What are these things, right? Let's look at some definitions that the state uses. So MCL 21134C defines residential real property as platted or unplatted parcels with or without buildings and condominium apartments located within or outside a village, city, or which are used for or probably will be used for residential purposes. Parcels that are used or probably will be used for recreational purposes, such as lake plots located in an area predominantly for recreational purposes. And for taxes, now this is for taxes now, right? For taxes, not for platted, but for taxes. Right? A home, a cottage, or a cabin on leased land, and a mobile home that would be accessible as real property under Section 2A, except the land on which it's located is not accessible because the land is exempt. Let's go back here. Right? What do they call real property? The real property is the home, the cottage, or the cabin on leased land. Well, do you lease your land or do you own your land? Because if you own your land, then, it's not covered. It's not real property. Just on leased land, a home on leased land. Does there have to be a house and property for it to be classified residential? No. As indicated above, the definition of residential property includes parcels with or without buildings. Yes, it does, right? There's a whole bunch of them. Right here, right? Residential, 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 and residential. And then res, conservation, reserve, rest. All those are some form of residential, and some of them are personal. Wrong way. So, it could be residential without any problem, but it can be residential personal property or residential real property. And that's all we're talking about is that difference. And where was that? Okay, right here. The classification of property does not affect the use of the property. Similarly, zoning of a property does not dictate the classification of the property. So it's zoned one way, but that's not necessarily the classification. And we're talking about the classification, right? And the classification that you want, as we'll see, is this 451. And, well, that's farther down the page here. So let's see what it said about residential personal property classification. So the same MCL defines residential real property as, for taxes levied before January 1st, 2003, residential personal property includes a home, cottage, or cabin on leased land. Right? Are homes, cottages, and cabins on leased land to be classified as residential personal property? No. Right? So those used to be personal property. Well, no, they're not now, which means now they're real property. Public Act 620 of 2002 has amended the definition to state that homes, cottages, and cabins on leased land are no longer residential personal property. For taxes leveled after January 1st, 2003, homes, cottages, and cabins on leased land are to be classified as residential real property. Well, if you own your land, then it wouldn't be a home on leased property. So you wouldn't register it as residential real property. Right? They wrote the thing backwards. Should home improvements to a mobile home park located in a licensed mobile home park, which is subject to a $3 per month specific tax, be treated as building on leased land? Yes, improvements to mobile home. So this is the thing is, do they consider your house a mobile home? Because they can pick any house up, put it on wheels, and drive it away, right? So every home is mobile. Some are much more mobile than others, but any house is mobile. And I've always wondered if they treat your house as mobile, right? So, but from that, it's like, well, yeah, you can have residential personal property. It's just by the definition. Say, my house is not on leased land. I'm the owner. Here's my warranty deed. Even though the damn thing is wrong, all right, here's my deed. Right? And say, does this not make me the owner? Now, who do you say all these things to? That's the next thing. Do you have to wait till you go to court? Can you do something ahead of time? Okay, one more thing in here. Now I have appeal procedure. So property owners that disagree with the assessor's decision, which means we'll start with the assessor first and see if you can just get it changed by going to him, must file a petition with the March Board of Review to appeal the classification. Right? Well, that's what this form is, right? Petition to Board of Review. Owner's name, petitioner's name, township, county, property identified, parcel code required, right? So make sure you put the frickin' county in there. This is the thing. See, they leave it off the paperwork, so we use their numbers, not knowing that what we're doing is using an incorrect number. But because we do it, well, then they agree. We never said the number was wrong. So they assume that we agree with them. As shitty as that is, right? So anyway, so the whole thing is you need to do this. Yeah, hang on a second, please. So anyways, it's this state tax commission that had the tribunal that found for the hotel against the city, right? But to have a hearing before them, you have to have filed a petition first. You got to follow their rules, right? So immediately in Michigan, you would be going down to find out what your property has been classified as with whoever has the records. And then if they won't change it there on the spot and give you proof that it has, right? Well, then you'd have to put in this petition. Now, that will be later on down the road. We're not there yet, but I'm just showing you, well, they got the document to do it, and they got the procedure to do it. And so if you don't like the number you have, you can appeal it. And this is the time of year to do it because it needs to be for the March Board of Review. Okay, so, hang on just a second again. Okay, so now, how do you find out where you're sitting today? Well, as it turns out, in the Michigan compiled laws, MCL 48-101, which, if you go to Michigan compiled laws and you put in this basic MCL search, and I put it in quotes, parcel identification number. If you don't do that, I'll give you like a bazillion hits, right? But you find these 10 different hits where, there's a whole bunch of laws written in Michigan, and there's only 10 of them that use the words parcel identification numbers. They don't like to use it very much. But in here, here's this title, section 48, right? And you can click on it, and then you can hit printer friendly. And when you're all done, you'll have what I'm looking at, right? But at the end of the day, it's a transcript somewhere that has all this information on it. One of those things is the property identification number. Another one's the owner's name. Who could that be? So, except as provided in subsection 6, 1, 2, 3, which must be this right here, right? Because, that's... A county treasurer shall make upon request a transcript of any paper or record on file in the treasurer's office for the following fees. Right? Da. Now, as used in this act, the qualified data file means an electronic data file that includes at least the following information in the record for each parcel of real property in the county for the current tax year. It has all these things in there, right? So this is what you want to get from the county treasurer. Right? You want to get your qualified data file for your parcel. And your parcel number starts with whatever your county number is. Well, what's my county number? Well, that's as easy as doing MICHI, Michigan County Numbers. And let's see what comes up. County codes. That's probably a better name for our county codes. And now I can make sure what Dana's is. Hang on a second. Kalkaska, 40. Kent, 41. That's why I keep thinking 41. That's mine. Kalkaska, 40, right? So there's the code. All right. Let's go back to our transcript. For each for an abstract of taxes and any description of land, right? So you got to pay a few cents to get this thing. But the record that you want is this record here that has all this information on it. So print this out, send it to the county treasurer, and tell them you want a copy of this record. And print it out, because now it really matters, well, who do they mean by this lowercase c, county treasurer? Right? Could that be the guy sitting down at the township hall? Because the county, lowercase c county is just it's a defined territorial land, but it doesn't have to be the same as a thing called Kent County, which is just the name of something. Right? So, but I would start with Kent County treasurer and ask them, and then I would go to the assessor at your or your township supervisor and say, you get it for me, right? Because this property is in a township someplace, right? All this shit is done at the local government level. Either a city or a township has the land records. All righty. And then what else is there? Okay, in this General Property Tax Act, right, they have a thing called an exemption affidavit. The information which shall be required for an exemption affidavit shall include the name and address of the owner of the property, the identification of whether the property is an integral part of a larger assessment unit or of multiple persons, multiple dwelling building, social security numbers of the owner, signing the exemption affidavit, and each resident in the homestead with an ownership interest, and identification by address or legal description of the property for which the exemption affidavit is filed, and the parcel identification number. Well, most of this information comes off of this transcript. All right, that's, things talked about in here. Because, going on then, domicile means a place where an individual has his or her true fixed permanent home, to which whenever the absent therefrom, the individual intends to return. This is the thing they're keeping from us because these records are wrong. We don't have a domicile. You don't have a homestead. Your name's not on these documents properly because there's errors in the records. And so, but if you had it properly done, you could get an exemption affidavit for your homestead. And I don't even know if it's the one that's called homestead affidavit, which, would make sense that it would be, but, that's the title of a document. I don't know if it's the same as what this thing does or not. And again, that's for a little bit further down the road. Right now, we're just trying to get to the point of let's get the piece of papers and go to the court and see what they have to say, or to this hearing. Right? Because, really, it's all based on this right here. Here's what Dana needs to do on the 20th, 12 days from now. There's probably other people in Michigan got the same thing. There's going to be a lot of people in court on 1/20/2021 having a show cause hearing, whether they show up or not. But if you had, if your objection was any of these things here, that could end it. And the evidence for these things here would come from this transcript. And how the affidavit gets done for an exemption and so forth, I don't really know. It's not that far yet. I'm going to get this far. Right? Get the qualified data file from whoever it is. See what they have for parcel identification number. See what all these things are. See what the property classification is. Right? And it's probably going to be residential 401 and say, well, that's wrong. That's going to be residential 451. Or, whatever it ends up being. But, I believe it's residential 451 is the proper classification. In fact, somewhere I had the definitions. Let me go find that. Okay, so along with the transcript then, right, is, what is residential personal property classification defined as. And so for taxes levied after January 1st, 2003, well, that would be now. Homes, cottages, and cabins on leased land are to be classified as residential real property. And you're going to say, well, I don't have leased land. I'm the owner because I have a warranty deed. Now, the fact that all these things have errors is something they're going to have to deal with. But you're going to go in there as, clean as the driven snow and say, well, I got a warranty deed. I'm the owner. According to this only residential real property only applies to leased property. This is wrong. It needs to be residential personal property. And, if that requires filling out a petition to do it because they don't want to do it, that would be one thing. But you could tell the guy, look, this is what's wrong with America, is this right here. Right? Do you want the Chinese to take over or do you want to fix the record? Because the old system is over. Either we're going to communism or we're going to fix the system we have today and have a republic. Right? But that's where your choices are. So, because the people that are running the local government now didn't start this situation. It's been this way for quite some time. It's all run by esquires, right? All of these townships, the people there aren't allowed to do anything. Anything they want to do, they have to go ask the fucking attorney first. It's the same in the county. Oh, we got to go ask the attorney first, right? There's nothing they can do. They're supposed to be the clerk's office, right? The clerk isn't supposed to ask anybody's permission. They're supposed to, issue orders. Oh, no, we got to go talk to the attorney, right? Attorneys are running the system. And they've got all these people buffaloed. And so, we need to put the fear of God back in them because right now they're under the trance of the devil. Attorneys were woed by Jesus multiple times, and they are enemies of the United States. So, they can either clean it up or they're going to go. But at the end of the day, this is how the deep state funds itself, by getting you to pay shit that you don't really owe and having you consent to it. Simply because there's an error in the records and you've never gone to get it fixed. Right? And, it's a maxim of something that he who fails to defend his rights has none. Right? That's what you're dealing with. If you don't defend your rights, you're not going to have any. And that's where we are right now. And so while we, going to wait and see what happens in D.C., we can start, you can kill the deep state by 1,000 cuts. Just keep taking their funding from them. Claim the property back, bring it back into the United States. They've taken all the property and they've put it into this, basically in their name in a private society, and they're holding the title. But they can't ever admit that that's what they're doing. So if you go claim it, they're going to have to give it to you. That's what we're going to try. We're going to see what happens in Kalkaska County. So, if you're from Michigan and want to try this and are going to get up off your ass and go do something, well, then, yeah, I'm willing to help you, right? But don't call me with a bunch of questions just because you're interested, right? Do it because you're going to go do something on Monday or as soon as possible. And when I know more, I'll do a follow-up video, right? But I'm just laying the groundwork on where we are today based on your property records, right? So remember this right here, right? If you're in Michigan, you're going to want to go ask until we find where to get this from, right? This transcript. We have to get the transcript so we can have a qualified data file with all this information on it, right? And it's an electronic data file. This isn't the computer. They should be able to just send it to you by email. So whatever it takes, right? And then come tell me what you found out so I can tell everybody else so we can push this freaking boulder down the road a bit. All right. I'm going to leave it there. Y'all have a great day.